Good morning, Judge Potterill. Are you well? Or is your mic on?
I've put it on now. Thank you. Sorry, I didn't for a moment. Good morning, Deputy Chief Justice.
How are you?
I'm okay.
All right. Are you comfortable?
I'm comfortable, thank
Good.
you.
Right. You hold 3 degrees, a BProc, an LLB, and an LLM.
Yes, I do.
Where did you obtain those qualifications?
My BProc I obtained at University of Pretoria. My LLB I did part-time while I was working. And then my LLM I also did, at UNISA. And then my LLM I did at the University of Pretoria.
You have a long career in the legal professions and the judiciary, starting in 1983 already.
Yes.
Can you just take us through your CV in that respect?
Yes.
Just briefly tell us where you started and where you are now.
I will. I've got 35 years in the legal fraternity. I started off doing estates, then a prosecutor, then a magistrate, civil and criminal. Then I went to Justice College where I trained other magistrates. Then I went to an independent bar because I fell pregnant with my child and they wouldn't let me work from home, so I went to an independent bar, and then I became a judge, and that's in short my career.
Mm-hmm. When did you become a judge?
In November 2009.
Mm-hmm. You practiced as an advocate for 10 years.
Yes.
Before that?
Yes.
All right.
I've been on the bench for 13 years, but the minister has accepted my 18 months continuous acting service, so I've actually been on the same bench for close to 15 years.
And I see that you've also acted at the Land Claims Court and the Competition Appeal Court.
Yes, I have.
And of course the SCA.
I have, yes.
Mm-hmm. How many terms have you acted at the SCA?
I did 4 terms, in other words, 6 months, 6 months.
And you are there now?
No, I'm not there now.
Last term?
I ended September last year.
Yes, all right. How many judgments have you produced at the SCA?
10 judgments.
And before that, is the other court?
Safely, I see the board, I didn't look, but it's 265, but Safely only started in 2003, so before that, it's close to 400 judgments.
I see that you've also been active outside the legal sphere. You chaired the Veterinary Council of South Africa at some stage, for a long time actually.
Yes, I did.
And you're a member of the Appeals Authority of SAPS.
Yes. I did that while I was an advocate.
Mm-hmm. And all sorts of other involvements. What is the SSSBC, PSBC, and GPSSBC?
Those were bargaining councils.
Sorry?
Bargaining councils.
Oh, I see. Okay. All right. How did you find your acting stints at the SCA? Did you cope well with the workload?
Yes, I did. I didn't find, look, you work hard, but I didn't, I really enjoyed it. In fact, I learned so much. And I never had an outstanding judgment. The judges, of course, gave comments, and you learn through their comments, but the substance of my judgments weren't ever changed. The only problem happened when, in 2016, my husband passed away. The last judgment was in the last week of that term. And I still sat, and then Judge Shongwe kindly said to me, all that, because we didn't have COVID, so we didn't really work by email then. But he said to me, go home, write the judgment, and we'll do it by means of email. And I went home, did it, and the judgment was out within the first 2 weeks after that.
Yeah, we realized just what a stoic you are during that period, because you're quite prepared to plow on and work despite your devastating bereavement.
Yes, it was difficult, I won't lie. Yeah.
You have always managed to have your judgments delivered on time. Do you have any reserved judgments now?
Yes, I've got one, which comes from 3 weeks ago when I had 14 opposed motion judgments that I had to write, and the last one is still outstanding, but it's halfway and it will be done before Monday.
So it's a fresh matter?
It's a very, very fresh matter, yes.
All right, thank you, Judge Potterill. I'll hand over to my colleagues now.
Thank you very much.
Do you have any questions for the candidate colleagues? AP Betse. Okay, go ahead.
Good morning, Judge Potterill.
Good morning, Acting President of the
How are
ACA.
you this morning?
I'm well, thank you. And you?
I'm surviving, that's all I can say. Thank you. Yes, you have already told the Commission that you are close on to 15 years as a judge.
Yes. Yes, IP.
And that you acted at the SCA for 4 terms, you say?
Yes, IP.
And from the list which forms part of your bundle, you have written many judgments in the High Court.
Yes, IP. I have. We're in a busy division, so you write a lot of judgments.
And how did you find judgment writing at the SCA?
I found it very interesting because no matter how you had read the SCA judgments in coming to your own judgments, when you're writing at the High Court, there is a different style. It's shorter. You must get to the crux immediately without leaving anything out. So I learned a tremendous amount from all the other judges at the SCA. Identify the crux and then write. And then if you've identified the crux, you also normally write correctly because you're not flopping around with what is the issue.
The feedback which I received from my colleagues about your judgment writing skills is not entirely satisfactory in that most of the writers informed me that when it came to judgment writing in the SCA, you were not, as it were, cruising on your own. You needed much assistance from the other senior members of the bench, especially the presiders.
I'm sure that there were many comments, but I can, for instance, say that the Shelton judgment, which I wrote for Judge Lewis, and the judgment that I wrote for Judge Mapati, very little comment, and those are the 2 reportable judgments, came forth. And those 2 judgments are often quoted in our courts. But I'm dead sure that some of the others may have said that they felt that they needed some comment here and there. And I took their comments to heart and accepted the comments where I thought that it was really, really necessary and learned a lot from that.
And during your last acting stint, September, was it 2021,
Yes,
I too allocated you a judgment to write.
yes. In that term, I wrote 4 judgments. I was allocated 4 judgments.
You wrote how many judgments
4
in one term?
in one term.
How did it come about that you, as an acting judge of appeal, overloaded with 4 judgments?
I don't know. I was surprised, but of course I wasn't going to question it. But 2 of them, I must be honest, were non-reportable judgments.
Yes. And did you receive any helpful comments from the other members of the bench in the matter that I had allocated you, which, as it were, enriched your judgment?
I received comments from yourself. As I can recall, I received comments from Judge Mbata, and I can't recall from who else, and of course it enriched my judgment, and I accepted those comments.
Yes. Okay, let me leave it at that at this point in time. Thank you, Judge Potterill. Thank you, DCJ.
Thank you very much, IP.
Thank you very much, Deputy Chief Justice. Good morning to everyone, and good morning, Judge Potterill. I'm here.
I see you. Thank you,
I'm
Commissioner.
My name is Sylvia Lucas. So first of all, let me comment on something that I have observed since yesterday. I think sometimes people come here and they expect us to treat them with kid gloves. Now you are applying for a very, very senior position. And I would expect the commissioners to be very tough on the candidates that come here. I want to commend your attitude on the way you responded to the question where negative issues was raised from others that are working with you. And I've noticed it's actually the woman that can take that kind of harsh questioning. Thank you, I like that, and I like the attitude that you displayed. Because I know where I stand and I know what I'm trying to do for women in South Africa, and it's very difficult. Now my question, what is your view with regards to how the outlook of the bench generally is now, and with regards to transformation within the judiciary? That will be my question.
Thank you very much, Commissioner. It looks better, but it's not there. If you look at the statistics, if you look at the people appearing before us, let me first of all start with the people that are appearing before us. When I acted as Deputy Judge President, I had to call the civil roll. And it was really heartwarming to see that in that we have a big role. I had like over 100 matters. So there's 2 counts on each side in 100 matters. So we sit in a big court. And it was heartwarming to see that more than half was black and at least half were women. And the women knew what they were doing. They didn't take nonsense. They fought their case. But what is not good is we don't see them yet in big matters. I don't know why. I know the Minister has taken some steps for briefing patterns. I see women as a 3rd counsel or a 2nd counsel. But I think what must happen is that the senior must give that woman an opportunity to talk. Us in court, we don't mind if they split the argument. It often happens. So give them an opportunity to talk Because it doesn't help they sit there and they're feeding the senior counsel, because they know what's going on in the matter. You can see it from the bench. They're telling them it's this page and it's that annexure and that whatever. So I'm unhappy that there aren't women doing the big matters, if we can call that. On the bench, our JP has transformed our bench very well. I think the white people are in the minority. The people that he's appointed is good people, and they are women. And some of those women were also here for the interview. So it's better, but it's not there. That's my answer.
So what do you recommend more, should be done more? Besides briefing patterns, but I can hear you say they've got the potential, they just don't get the opportunities.
Yes.
So what is your proposal?
I think as far as the bench is concerned, I think if they implement again that aspirant judges training course, because from that a lot of people were appointed, so I think that will really help. They must continue with the training. There is training for attorneys, and there's at the bar training. So I think that must continue. So training is important. Also, the JP will know this, and I think he can support me in this, that whenever I sit with an acting judge, I will write to the JP and say, this woman has got potential, please call her again. This woman has got potential, please ask her to apply. I do so only when I've worked with that woman, but I do that on a regular basis.
Thank you. I just want to make a comment to say, I think you will agree with me that what we need in the judiciary is consistency.
Yes.
And that is what will be important. Thank you, CJ.
Thank you very much, Commissioner.
Thank you very much, Deputy CJ. Good morning, Justice.
Good morning, Commissioner.
Yes, the last time you appeared before the JSC was last year in April.
No, I've not appeared before the JSC in April. My last time was, I've never applied for the SCA post.
Is it for the first time you are applying?
It's the first time I'm applying.
Yes. Now, there is a big problem within the judiciary of briefing patterns, especially for women, black women. What is your view on that and how that can be improved, since in terms of your CV, you advocate for women emancipation and empowerment?
Yes, definitely. Women are good judges. I know that's a general statement, but as a judge, you need to organize. You need to be able, especially in a big division like us, where it can become overwhelming. So you need training, because judgment writing is not a skill that you come with. You've come from the bar, or you've come from the attorney's profession. So you may have drafted heads, but you haven't written judgments. So when acting judges come, you must help them with their judgments. You can't leave them on their own and say, oh, this is a bad judgment. So all of that I'm saying because training is absolutely necessary. We need to train people to do that. The briefing patterns, we can just keep on urging. I can say, why is this council not saying anything? But from the bench's side, there's not much we can do except say, please brief women, because we're not doing it. And when I train, which I do at the bar a lot, I say this. I say it over and over. And I do think that it's getting better. I just wish it would be perfect, and it's not perfect yet.
All right, thank you. Thank you very much, DCJ.
Thank you very much, Commissioner.
Commissioner Moimang?
Thank you, Deputy Chief Justice. Good morning, Justice Potterill.
Sorry, I can't see you. Oh, there,
This side.
thank you, sorry. I d-
Thank you, Justice Potterill. My question relates to one of your judgments that impacted on the composition of the cabinet. I guess the Fireblade Aviation versus the Minister of Home Affairs rings well to you.
Yes,
Yes, because of the disputed facts from the minister that he did not grant the Fireblade an ad hoc facility or a port of entry, you came to a different conclusion. Was that not an overreach? Thank you.
no, I don't think so. I don't think it wasn't a question of me having to make a different decision. I had to decide whether in fact he had made that decision. So I don't think it was an overreach. And they did appeal and the petition was not successful.
The basis for that decision, was it informed by the discretion that the court has in terms of resolving the matter where there are disputes of facts?
Yes, you do it then in terms of the Plascon-Evans rule, or which has now been, as the SCA, entrenched with NDDP versus Zuma and the Whiteley matter, etc. Yes, so you do it in terms of the Plascon-Evans rule.
Thank you, Justice Potterill. Justice. Thank you, Deputy Chief Justice.
Thank you very much, Commissioner.
Commissioner Nyambi?
Thanks, DCJ. Morning, Judge.
Good morning, Commissioner.
Have you seen the objection by Mr. Masuku
I did.
alleging that you lack understanding of the law? What's your comment about that?
It saddens me that he thinks that. I don't know who he is. But I think he's, sorry, I'm under correction. Didn't he say I'm ill-treated, the public protector? Did he, sorry, I'll just have to look. Did he say I didn't have an understanding of the law? But I'll answer your question in that vein then. I do think I have an understanding of the law. I think my judgments speak for themselves. Of the 15 years, I could find 5 matters that the SCA had overturned. I couldn't find any more.
What is the difference between judicial independence and judicial accountability, if any?
Judicial independence means exactly that you are impartial, that you aren't influenced by anybody, and you look at the facts, you look at the law, and you apply them, and of course the Constitution is always part of that. That's judicial independence. Judicial accountability means exactly what the Code of Conduct of the Judicial Code of Conduct and the norms and standards say. In other words, you must be diligent, you must be impartial, you must be transparent, you must do your work diligently, you must apply the Constitution, you must try and be transformative in your judgments. That is judicial accountability.
My last question is about the acting stint as a JP in Gauteng Division.
As the DJP, deputy, yes.
Yes. If you can share with us your experience, coupled with your acting stint as a judge in the Constitutional Court of Lesotho.
Yes. Can I start with the Lesotho first? I enjoyed that tremendously. I wasn't alone. I went with Judge Musi and, oh gosh, now I can just remember his name. And it was really very interesting to do constitutional work there. We sat at the hotel, wrote the judgment together, and we did 2 or 3 matters against the president. So they get people from outside to come and do that because everybody there is just too close to home to do that. So that was very interesting, and we delivered the judgments. As the acting deputy judge president, it was a difficult time because it was just when COVID hit. We didn't have any computers. The computers we had didn't have cameras. The registrars had desktops that weren't compatible, but we managed to keep the court roll going. And in fact, I managed to go and look and draw statistics, and I just drew one statistic. And that statistic was that from the 5th to the 30th of October 2020, as the civil trial role, which was my main duty, besides all the administrative work, I allocated 1,705 matters, of which 1,895 matters were RAF matters and 152 matters were non-RAF matters, and there were 58 removals by the parties. It also happened that because of the malfunctioning, sometimes matters weren't placed on the roll. We made WhatsApp groups so that the people could reach my registrar so that I could see if I could place the matter on the roll. And the matters that we couldn't allocate, at the end of each week, because if there weren't enough judges, I'd arrange with the registrar that in the next 6 months, 4 weeks were left open, and those matters were placed in those weeks so that the people could get speedy justice.
Thank you, Judge. Even though I thought that there's no president in Lesotho, I misunderstood you and said president of Lesotho. Thank you, TCJ.
Thank you very much. Thank you.
JP Mlambo?
No, thank you very much, TCJ.
Sorry, JP.
Is it a follow-up?
Yeah, just on this one.
All right.
What do you mean by president of Lesotho?
Yes, I'm sorry. That was a miss. It was the minister that was in fact party to the proceedings. Thank you, Mr. Malema, Commissioner Malema.
I'm covered.
Thank you very much, TCJ. Good morning, Judge Potterill.
Good morning, JP.
I just want to deal with the judgment writing experience. Before you went to the SCA, am I correct that you'd sat in a number of special motions and full court appeals in which you were the senior judge?
Yes, that's correct, JP.
And am I correct that you took a lion's share of those judgments? That is, you wrote them?
I do. If a judge offers, I will give them an opportunity. But as the senior judge, you are supposed to take the role.
Yeah. And in writing those judgments, am I correct that a number of them have been appealed against unsuccessfully and have been upheld up to the Constitutional Court?
Yes, that is true. There's only, as I say, 5 that I can find that wasn't upheld.
Yes. But this is a point I want to come to. Your judgment writing was that of a High Court judge. But when you went to the SCA, you found that judgment writing was a different animal altogether there.
Yes.
And you were prepared to learn and embrace the learning you got in terms of how you write SCA judgments.
Well, the first thing that you have to learn is that you're not writing for yourself.
Yes.
You're writing for 5 people.
Yes.
So that in itself is a different experience. And you've got to satisfy them. And because that is a national court, that the rest of the country, of course, excluding the Apex Court, looks to, it's got to be a superior judgment, if I can say that. So yes, you have to learn. It's not a skill that you have immediately, but I do think that I've conquered it and will conquer it completely.
Thank you, DCJ.
A follow-up, DCJ?
So, oh, go ahead.
Thank you very much. Good morning, Judge.
Good morning,
I just want to follow up on that issue because it's something that really troubles me. That a judge will have 200 plus judgments from the High Court, and you get to the Supreme Court of Appeal. Suddenly, there is this view that perhaps your writing is not up to par, and you need to conform to a particular style. And we know that that style is not even consistent with the style of the Constitutional Court. I'm not really, I just want to understand this style of the SCA, shorter judgment, get to the, because I've read of late very concerning judgments from that court. What informs this view that if you write shorter, suddenly the judgment becomes of quality? Obviously, if you write longer, doesn't necessarily mean that it's quality. I just want to understand what is this thinking at the Supreme Court of Appeal in relation to the writing of judgments, that when you get to that court, suddenly there's this style that we need to conform with. And for me, it seems like judges who are coming from the High Court, or certain judges that are coming from the High Court, suddenly when they get to that court, they appear not to be good enough because of this style. I want to understand this style.
I understand what you're saying, but I just want to say to you that when you get there, you're not treated badly. Or I wasn't treated badly. It's not as though they say, go and write it over. So they sit down with you in the conference. When we have a conference, it's not a situation of you feel like a complete idiot. I think it comes from them being able, after so many years, to write a good judgment concisely. Where we start off like, if I can say like you would write in an essay. When we start writing at the High Court, you sort of say who the parties are, what the pleadings are, what's the common cause facts, what's the problem, and where they condense all of that beautifully without having long-winded, unnecessary. And I'm not saying all long judgments are long-winded or unnecessary. Sometimes a long judgment is necessary. So I agree with you. But it's a certain style, and remember, it makes it easier for a High Court judge to read, because we've got to read their judgments, because we must conform to their judgments in that sense. So yes, it's daunting. You're right in that sense, because you after you've written so many judgments, you think you know, and then you come there and you don't. But it's a learning curve, and it's not a bad learning curve. It's a good learning curve.
Thank you very much, Deputy Chief Justice. But I just need to say this. But it is surprising that the very same judges of the Supreme Court of Appeal, they then get elevated to the Constitutional Court, and they start writing long judgments. Like, for me, it doesn't really make sense. Thank you.
Thank you, Commissioner.
Is that a question, Commissioner Professor?
It was just a
You're venting. Commissioner Matolo Dlebu?
Thank you, dear Deputy Chief Justice. Good morning, Judge.
Good morning, Commissioner.
How are you?
I'm well, thank you.
Okay. Well, one of the things that I wanted to find out, I see that there was a comment that you are very committed to transformation. But I just want, everybody is committed to transformation, but I want you to tell us that you were self-employed practicing attorney advocate from 1998 to 2008. How many young black females did you take along? And how are you satisfied that you really, because you can't suddenly complain about transformation when you are a judge. Did you play your part when you were an advocate?
Yes, I did play my part, not only by means of training, but also you can see I trained at everywhere. I find that because you get to know people and you can take people along if you train. Training is such a good basis. And because I wasn't a senior counsel ever, I couldn't always have a junior. Like, you know, I had to look at the bar rules. But wherever I couldn't do something, I gave to a black. I must admit at that stage, and I'm just going to be dead honest, there weren't a lot of black women. But I gave to a lot of black men. And if there was a black woman, I would give to her. The question about the transformation was about the Lawrence judgments, I think, from the SCA.
Thank you. A follow-up. The BLA has made a comment that one of your judgments, just trying to get to it.
Yes, it's the Lawrence judgment.
Yeah, the Lawrence, that it shows your lack of understanding and conscious of transformation. Can you just clarify that and please put my mind to rest?
Yes, I would do so gladly. What happened was, it was a matter which we had at the SCA. Lawrence was a white magistrate who had applied for a post and he didn't get the post. And he then asked for a review of the Magistrates Court Commission. I beg your pardon. It was really, for me, quite an important judgment to write at the SCA because it was the first time that I could see that there was going to be a judgment on Section 174, and specifically Section 174.2, which of course says that the judiciary must reflect race and gender. And of course, Mr. Lawrence does not do that. He's not race or gender in that sense. But the Magistrates Commission had a policy with criteria, which they had to follow to get to an appointment. And they did not follow that process, first of all. And secondly, of course, it's a constitutional imperative that race and gender must play a role. They made it the guillotine. So if a white person had applied, they just threw that person off the table. And that is what the judgment says. So the Magistrates Commission, the Constitutional Court has said, you can't not comply with your own process, you can't have a rigid system, you can't have a quota system. But the Magistrates Commission could have complied with Section 174 by just adhering to their own policy. In other words, what they would do, which would satisfy everybody, is put Mr. Lawrence on the table, because it was common cause that he was an excellent magistrate. He was training, he was helping, he was whatever. So put him on the table with other candidates, and then use Section 174 in brackets 2 and say, but he does not comply with race and gender, and therefore we cannot give him the post. So that is what was wrong. Judge Mola wrote a minority judgment on the Potterill post. She felt that the Magistrates Commission, if you read the record, didn't do that to Mr. Lawrence pertaining to the Potterill post, but did do it for the Pietersburg post. And she phoned me. We had a decent discussion, and I said to Mahubi, or Justice Malum, write and let me look at it. And when she did write, and when the rest of us looked at it, we disagreed with her because it was common cause on the facts that they used exactly the same process. The Magistrates Commission did not appeal this finding because I think that they realized they didn't follow their own process. And if they just followed their own process and used the criteria correctly, they could have gotten to the same result.
Thank you, Deputy Chief Justice.
Thank you.
Thank you, Commissioner.
Commissioner Malema, your hand had been raised earlier. Do you still want to pose questions? Go ahead.
Thank you very much. Morning, Judge.
Morning,
There is
Commissioner.
this think that you are the most preferred person when it comes to high-profile cases there in Pretoria, and where JP sits in those cases. If it's a full bench, you are likely to be part of that full bench. Is that correct?
Sorry, can I just rephrase? Are you saying that I sat on a lot of full benches with the JP?
Maybe let me start with the first one.
Okay.
There is this thing that you are the most preferred judge when it comes to high-profile cases, one. Two, despite the fact that there are more senior judges there, you'll always be picked for high-profile cases. And two, that you'll sit in the most cases where there is a full bench led by the JP.
Can I start with the second question?
Yes.
I sat in one full bench with the JP. No other full bench have I ever sat with the JP. So I don't think that's correct. I don't know. The workload is divided as follows. There's no preferences. The JP has a roster which he hands out the 2 weeks or 3 weeks before the next term. So you get a roster, and you allocate it according to that roster. So I want to say that except for the equal education matter, which I'd said to the JP, there's 3 urgent matters. We haven't got enough judges when I was DJP. I'll do one unless he can get me another judge, and we can do the others. I've been allocated according to the roster, not special circumstances. And the only one, as I said, that I can honestly say was equal education, where I sort of offered because there just wasn't another available judge. You must also remember that urgent matters come in, which would be high profile, okay? And they write to the DJP and they say, look, I'm issuing this, you must get me a full court, you must whatever. So we then write back to them and say, okay, that's fine, we'll try and see, and you're sitting praying, hoping a judge becomes available. We don't have extra judges. So by the time the matter is ripe for hearing, the DJP then phones the JP, and he says, I've looked, no judges come free on the opposed motions, no judges come free on the third court matter. Can he free up somebody? And we often then go to the civil trial court because there we can free up somebody. So there isn't a preferential system.
Have you ever written a judgment for another judge in a matter where you're not involved?
No.
There has never been such a request?
No.
I see you were in the Transnet Group Tender Board.
I was what?
Have you ever been in the Transnet?
No.
Okay. Thank you, Deputy Chief Justice.
Thank you very much, Mr. Malema.
The alarm that just went off a minute ago was indicated the expiry of her 40-minute allocated time. So let's keep that in mind going forward. Commissioner Nikias?
Thank you, President. Good morning, Judge.
Good morning, Commissioner.
I think I've only one question.
We can't hear you, Commissioner Nikias. Just bring the mic closer to you.
All right, thank you, Tshipi. Would you agree with me that the appointment of a judge in the High Court and the appointment at the SCA or Constitutional Court at least should apply different standards? In respect of the High Court, at least a candidate must have some potential, and then you move from there. But with the SCA, certainly it must be conclusive.
I would agree with that, Commissioner.
And therefore, in that exercise, your judgments are a consideration. That's where we should be starting from.
Yes, I agree, Commissioner.
I'm not too sure whether you have read this. I don't know what it is, whether you responded in the objection. The first one was what Commissioner Nyambe talk to the objection by Mr. Masuku.
Yes.
Then there is a second statement, which is from Melanie, I'm not sure.
I'm not sure who that is.
But you have read this,
I've read it.
and you had time to reflect on the issues that are raised. The allegation is that when you write judgment, you use harsh language, disparaging, and I mean, as it is said. What is your comment on that? That is, you use strong language to an extent that the higher court, the constitutional court, had to rebuke, has to express its concern about that.
Yes.
Do you agree that that did happen?
No, I don't know where that happened. I've never seen a constitutional court judgment where they addressed me on harsh language. I take note of the criticism. And in fact, when we had a Sajay training session, we spoke about it.
Yes.
Because it wasn't only me that was saying, they weren't only saying that I wrote hard. So you've got to take cognizance of what people are saying. Yes. It can't affect your impartiality. Yes. But you must look at what they say. And so we must, I think what one must do is read your judgment, put it down aside. Next day take it and read it again to see if you think there's any harsh language. But the language that I was, as I understand it, what was said was that I had used the word nonsensical. And that word I grew up with. If you look at the case law in the SCA and even in the Constitutional Court, and I can quote the matters to you if need be, they use the word nonsensical. So I didn't find it harsh, but I take note.
Yes. Oh. Otherwise, you did acknowledge that, at least referring to nonsensical, whilst from your own perspective, you don't intend to sell, but
No.
culturally and other people would interpret differently.
Well, now that you use the word culturally, I've in fact asked my colleagues, is there something culturally wrong with nonsensical? Now, most of them have said no, but one says to them it means you're nonsensing them. And I take that to heart.
And then, were you not involved in the reserve, were you not writing in the
No.
Public Protector and Reserve?
No, I was not involved in that at all.
Okay. Lastly, in terms of you seeking an appointment to the SCA, can you state what is your jurisprudence? What is your judicial philosophy? And how you have applied in your case law?
Yes. I think the Constitution has given us as judges a because remember, a judge is not a lawmaker. We can't write laws. But what you can do is you can develop the law. And the Constitutional Court, the Constitution, Section 39 in brackets 2, has given us a free hand within the pleadings and within what the parties have put before us to look to developing the law, and even, I want to say, I always, when I'm writing, try and think of a rights-based law. In other words, what rights are here, not only precedent. And of course, I must follow what the Constitutional Court says and what the SCA says. But you can develop in between those borders, and you can develop a more rights-based jurisprudence than just following precedent. And I think I've done so. I think I've done so in the Naduma matter, and I think I've done so in the equal education matter.
Commissioner Mokonish.
Thank you very much, Commissioner.
Thank you very much, Deputy Chief Justice. Good morning, Judge Potterill.
Good morning, Commissioner.
I have 3 quick questions. The first one, what would you say to people who believe that the law is the weapon of those who owns the means of production to consolidate their power in society? Do you have some sympathy with that view?
Rich people can litigate, that is true, and they can use the best counsel, that is true. But they can't manipulate the law.
Are you done?
I'm done.
Okay. So you don't have any sympathy with that view?
I do. That's
Okay.
why I started off by saying, rich people have an advantage.
Okay. The second one, there is also a view that says the Supreme Court of Appeal, in terms of access to justice, is an unnecessary layer. It must be merged with the Constitutional Court. Do you have sympathy with that view?
I think if it can practically work, then yes. I just don't know. I've never acted in the Constitutional Court, so I don't know the workload. I assume that the extra justices will have to be appointed. So I just don't know the practicalities of that. But there is a lot of talk about that, and I've got no negative view or. The nice thing about the law and the functionaries of the law is that the law is never finished. That is why our symbol is not a round circle, because it's never finished. And so development will take place. And whenever that is suggested, I'm sure the powers to be, like our 2 learned colleagues sitting there, will know how to go forward pertaining to that, whether it's wise or whether it's not wise.
The last one, in your experience as an advocate and a law lecturer, don't you think that there is something that I would call malicious compliance to ensure that people are perpetually trained and not much is being placed on sharing the cake in the briefing patterns, that as much as training is important, but it is being used to avoid to radically transform the legal profession in ensuring that people get the actual work, meaningful work, that people just use this issue of perpetual mentoring and training as a way of sabotaging transformation? I'm not sure whether I must repeat.
No, I did get
Just
that.
hold on just 1 second.
Thank you.
Judge Potterill.
I'm happy it happened when Commissioner Magwanishi was speaking.
Why, Commissioner?
He knows. And all of them next to him know why.
Oh. Commissioners Bernard and Breitenbach, are you back with us?
Like to ask a question, please?
Oh, I was just checking if we had a blink. We were just load shedding. And I just wanted to make sure that you are still on the platform. Carry on, Judge Potterill.
Thank you very much. Training and not leading to a result means nothing. So I agree with you. in the sense that training and mentoring must lead to active participation, and that we must ensure that.
Thank you very much, Deputy Chief Justice. Thank you very much, Judge Potterill.
Thank you, Commissioner.
Commissioner Pillay?
Thank you, DCJ. Good morning, Judge Potterill.
Good morning.
And just to follow up on the question from Commissioner Mahwanishe, I heard you answer your questions about the transformation of the system and the advancement of women. You did it in the context of women at the bar. You did it in the context of aspirant judges. And I just want to turn for a second to the experience of women after their appointment. In other words, I just want to touch on advancement within the ranks of the judiciary. Now, for me, it's a cause for concern that there are 15 heads of court positions, and not one of them occupied permanently by a woman. I think there's one position where there's an acting woman appointment, that's Judge Meer. But apart from that, the positions that are occupied, and I think there's one or two that are not occupied, but the positions that are occupied by men.
Mm.
Now, that raises the question as to what are the obstacles to advancement for women within the judiciary, and why is it that we're not seeing women fill these crucial positions of leadership within the judiciary?
Yes, you're right. I mean, it's glaring that there is, except for Judge Meyer, just nobody. I am thankful to see that for some of the posts now, which are DJP posts, at least they are women, and I'm sure they'll get it. So there's a start. But I think there must also be leadership, because leadership courses, and I think we must suggest that to Sajay, because what happens was, I think, I'm sorry for the men here, but I think women have a natural ability to organize. And I'm not saying men don't, but a lot of women, so that we've already got that. But I think you're so trained in the law that I think we must put ourselves out there for leadership. Because I think we're so trying to prove ourselves as judges that we're not even thinking of leadership roles. But I see that when we now have conferences at the IAWJ, people are talking about leadership. We need to fix this, because I'm sure we'll be able to fix this. So I think I'm so glad you raised this question, because I think we must put ourselves out more for leadership. I don't think the women are putting themselves out for leadership. And there's now enough women who has experience that can really do that. Perhaps 10 years ago, women didn't have enough experience, but now there's enough women who has experience to do that.
Thank you, Judge Potterill. And you see that touches in with a point raised by Commissioner Mahwanishe, which I wanted to raise with you. It answered to one of the questions around transformation. You said that there needs to be more training. And I have a very great concern with the narrative that women have to be trained, because inherent in that narrative is that there's a lack of opportunity for women at the moment because they're not up to the task, because they're not equipped for the task.
I hear what you say, and that is a problem. But if they're not getting briefed, so they're not getting practical experience, at least the training is a substitute. So I hear what you say. It means as though, women need training and men don't. But at least that gives them a foot in the door, I feel, versus because they're not getting briefed, or they're not getting, so I think that's the purpose of training. But I agree with the other comment. Training per se is not going to help if it doesn't lead to a result.
And what that leads to, Judge Potterill, is at some point, us as women and society as a whole, we need to start dismantling and exposing the system for what it is. We need to grapple with the elephant in the room. Why aren't women accessing the work? Why aren't women accessing leadership positions? And the reality, unfortunately, the stark answer is there's just a lack of political will. No matter how much women are equipped, no matter how much they are trained, no matter how much of experience they have, they are simply unable to access these opportunities. And then the big question is, How is it that we grapple with that elephant in the room, with the lack of will out there? It's really men clinging onto power and perpetuating that power as they go forward.
Yes, I agree with you, but I'm very confident that we'll get them off their thrones.
Thank you, DCJ.
Okay.
Thank you very much, Commissioner.
Go ahead, Prof.
Thank you very much. Judge, I just want to talk to you because I've had occasion of reading several of your judgments. And quite frankly, I find the judgment that you wrote at the High Court way much better than the judgment that you wrote at the Supreme Court of Appeal. And I will explain to you why. I will explain to you why. There is a matter where you appeared, Klein versus Smith versus Kleinhans.
Yes.
You remember that matter?
Yes.
In this matter, I think you arrived at the right conclusion, where you came to the assistance of Mrs. Smith. But the reasoning leaves much to be desired in this way. In that matter, the issue was re vindicatio, as I understood it. It is not clear on the judgment why, what then should be proof of ownership where there is an installment sale agreement in order for you not to be able to claim your property from the person who lawfully possesses it. And the judgment is relatively short, of course, but you reject the fact that re vindicatio is applicable here because ownership could not be proved. But in the judgment, we don't know why ownership could not be proved. There's no an explanation of why re vindicatio under these circumstances is not applicable. And I think that particular explanation is important. There is this perception of people saying judgment must be short for the parties. Judgments are not written for the parties. In South Africa, judgments are written for the public. The outcome is important for the parties. But the judgments are important as teaching tools as well as university. So when I'm confronted with a judgment like this and I'm teaching property law, I'm unable to assist my students to understand why I say the outcome is correct, but I'm saying the reasoning is wrong. I'm not sure, do you have any view then?
I haven't got the judgment with me, but I do recall it. And I'm now going to be under correction from you.
Yes.
Because I haven't got it in front of me. But as the claimant could not come with the re vindicatio because in terms of the installment sale agreement, she's just the bona fide possessor. The bank is still the owner of the vehicle. So the re vindicatio is not applicable. So the question then was, what stronger right did she have to possession of this vehicle than the respondent in those circumstances?
You are right, but that reasoning doesn't come out in the judgment. That's where the problem that I'm trying to raise. That's why I'm saying that the conclusion is correct. Thank you very much. Thank you, Deputy Chief Justice.
Thank you.
Any questions from the virtual platform colleagues?
Please, Acting Judge Present. But Mr. Bonner can go first, it's fine.
Okay, go ahead.
Thank you, DCJ.
Just look at the TV screen in front of you,
see.
Judge. Yes, good morning.
Good morning, Commissioner.
Morning, Judge. The commissioners might, I'm going back to the Lawrence matter, so commissioners might easily be tempted to focus on the section 174.2, you know, the need for the bench to reflect the race and gender composition of South Africa, and use it and exclude category white males or other category of race and gender. But the Magistrates Commission versus Lawrence matter, you dealt with the dangers of this. Which mistakes would you say the JSC in these interviews should avoid? Particularly in these interviews and the SCA posts, there are various white males and females that are applying, and there's 11 posts, 5 posts, but 11 candidates. So what are the dangers that we should avoid, or the mistakes that shouldn't be made if you think back to the Lawrence SCA judgment?
Well, I'm most certainly not going to prescribe to JSC commissioners how they should come to a conclusion. And they've got the constitutional imperative to look to race and gender. So if I use myself as an example, they can put me on the table if they think I have the competence and I have the experience and I've proved myself. And then they must look, okay, gender perhaps, but race not. And then they must apply that whether in their circumstances a white woman is acceptable or not. But I'm definitely not going to prescribe to the JSC commissioners how they must come to a conclusion.
Thank you very much. The specific mistake made in that matter, what was the problem with the Magistrates Commission?
What they did is they simply did not consider any white candidate.
Thank you very much. Thank you, DCJ.
Commissioner Bredenbach.
Thank you, Justice. Good morning, Judge Potterill.
Good morning, Commissioner.
You'll agree with me that ethics, courage, and integrity are important attributes in any judge.
Yes.
And I would like you to explain how you think these attributes manifest themselves in the way you conduct yourself on the bench.
Ethically, transparency.
The end. But before we let you go, I just want to say something, and I don't mean to irritate my colleague, Professor Marumo Akai. It pertains to the concern he raised twice with you about the SCA's judgment writing style. And what I liked about your response is how you described it. And I'm going to sum it up in my own words, that you learn to identify the real issues in the dispute with precision. You get rid of the clutter and red herrings and produce an opinion that is written simply, whilst keeping everything in, all the substance, but it's written simply in simple language such that everyone, anyone who reads it can understand it and read it to the end without getting tired. Did I sum it up properly?
Perfectly, and that is a skill.
It is very difficult to write like that.
It is a skill.
Is there anything you would like to ask of the Commission before we let you go? All right. Thank you so much for presenting yourself to the Commission.
Thank you very much.
You're excused.
Thank you very much for having me.